Ms. Bauer, can you open the session for us and let us know what
Good morning,
going to do
Madam
today.
Chair, panel. Morning. We're calling Mr. Hofmeyer this morning, and he is accompanied by Advocate Anna de Theat from the Pretoria Bar, who will assist him if required.
Arunse, you had wanted to address the panel before we start with Advocate Hofmeyer.
Madam Chair, I've indicated to you offline, and then I'll place it on record, that we wish to address the panel before Mr. Hofmeyer starts with his testimony. I have also indicated this to Ms. Bauer.
You can go ahead.
Thank you. Madam Chair, I'm not sure to what extent the panel has read or perused Mr. Hofmeyer's affidavit. But if you have, and any one of us who have had an opportunity to read it, it is replete with allegations against Mr. Abrams, the former NDPP, whose appointment was declared unlawful by the Constitutional Court. As far as I understand the judgment, for reasons of legality, his appointment was declared unlawful. He was not declared not a fit and proper person or not otherwise qualified for the job. However, Mr. Hofmeyer, in his affidavit, makes allegations which, if true, are very, very serious. If they're not true, they are plainly false and defamatory. Our job is not to defend Mr. Abrams. So we inquire whether the evidence leaders had indicated to Mr. Abrams that there is an affidavit which quite liberally is scathing of him. If this has not been the case, then we want to register our gravest concern with that state of affairs. Upon inquiry, Mr. Abrams has indicated that he has not been contacted by the evidence leaders and has not been asked to comment on Mr. Hofmeyer's allegations. We know from our pre-hearing engagements, and we know from the rules, that the panel places an absolute premium on the rules of fairness, and quite rightly from time to time have even brought us to order, as it were, when we cross-examine witnesses. Now, we think it is vitally important that either Mr. Abrams be given an opportunity to respond to these allegations, even better for him to be called or to be invited, since you don't have the powers of subpoena, to be invited to give evidence here in this inquiry. We are concerned that if the allegations against Mr. Abrams, which we would certainly be in a very difficult position to contest, stand, that our client, Ms. Jiba, would somehow be found guilty by some association, which seems to be the trend of Mr. Hofmeyer's affidavit. So we register that concern. The other concern relates to Mr. Hofmeyer's comments, observations, conclusions on various cases that are in fact pending before our criminal courts, when he is not directly involved in any of these cases. And again, we ask the question whether the prosecutors involved in these cases and or the directors who are supervisors and management of these cases have been approached for comment on these cases. Of course, the biggest danger of airing the merits or demerits of these cases in a forum like this is that, one, they are live, two, they are accused in these matters. Now, we know that Mr. Boyson, for some reason which we will no doubt establish when he appears, has elected to give evidence here which is quite extraordinary, that an accused person in a criminal trial wishes to in advance of a criminal trial, give his side of the story, as it were, and to be cross-examined. We trust that he's not going to invoke his right to remain silent when he gets cross-examined on the merits. So the danger is that Mr. Hofmeyer, who sits here and who prides himself as being almost a foundation founder member of the NPA, is in danger of bringing that institution into disrepute. The stuff that he has said in his affidavit must be like manna from heaven to any defense counsel. So we caution against that, and we would want to place that on the record. Then, just lastly, the affidavit of Mr. Hofmeyer and Mr. Kasana was tendered by the DA as evidence in the matter before Judge Delamo in the Western Cape High Court, and those affidavits are in the Dropbox. I am not sure whether Ms. Bauer is aware, because certainly if she's not, and anybody who reads those affidavits would not be aware, that those affidavits were not admitted by the judge, the presiding judge. Ms. Jiba's affidavit in that matter, opposing the admissibility of those two affidavits, is not in the Dropbox and should be. And also, of course, the DA's reply to that affidavit, to place it in proper context. Thank you, my lady.
Thank you, Mr. Arendse. Can I ask you, Ms. Bauer, to respond if you have any response?
Can I maybe first deal with the latter query? Advocate Jiba's affidavit and that of the DA is indeed on the Dropbox. What I had done was I moved Advocate Hofmeyer's affidavits to folder M for convenience, and I told the parties that. But the full court records of the matter which appeared before Delamo J is in fact in the court records bundle under G number 6, and you will see that it is under 6.4. It is indeed there. So my convenience of shifting Advocate Hofmeyer's to one place was to isolate it for today. Can I maybe, just on the second point, can I ask if I understand Advocate Arendse's queries to relate to the affidavit which had been deposed to by Advocate Hofmeyer just get the date of the affidavit, on the 31st of March 2015, in relation to which the allegations are made against Advocate Abrams. Or is he referring to all three affidavits in that regard?
I'm referring specifically to the affidavit that was deposed to, I think, on the 15th of January, or this latest one?
The latest one?
Yes.
Right.
I know that in prior court proceedings, where Mr. Hofmeyer makes allegations. Obviously, Mr. Abrams was there as a litigant, as an NDPP, and would have responded to some of those allegations. The ones in his affidavit before you today is a lot more direct and a lot more personal.
Maybe
You may
for
respond.
my point of clarity, could you point out to me specifically which allegations in that affidavit you are referring to?
Possibly not necessarily allegations, but paragraphs. Wouldn't that be more helpful?
Apologies, I am referring to the paragraphs.
Malady, can
Yeah,
I just do that? Can we just have a very short adjournment? So
I
we
think
can
that would be
find-
appropriate. Ne? Yeah, that would be more appropriate. And then how long would you need to do that?
It won't be longer than 10 minutes.
10
10
minutes?
minutes.
Can I find out from both counsel, if the paragraphs are pointed out, would you have an alternative, I'm looking for the English word, could find the Tswana one, of finding out whether the possibilities of striking out those paragraphs are appropriate or not appropriate, depending what positions you take in this time we've given you?
Maybe I should place my position or view on the record before Advocate Arendse does that. It was made very clear what the subject matter of this inquiry is. This inquiry relates to Advocate Jiba and Advocate Mokgoro. I understand that if you are going to make findings in respect of a person, or he's going to be implicated in some sort of a way in this inquiry, then they would have an entitlement to a hearing before such findings are being made. This inquiry is doing no such thing. It was made very clear at the pre-hearing, you are not civil proceedings, not the criminal proceedings. You are not making any findings of guilt or innocent or testing the veracity of it. So my view, frankly, is that whatever Mr. Hofmeyer has to say about Mr. Abrams, if Mr. Abrams regards that to be of a injurious nature, then that must be dealt with by Mr. Hofmeyer and Mr. Abrams in another forum. It is not within the terms of reference of this forum, and you can certainly take the weight of that evidence into consideration when you deal with the matter. Advocate Mr. Abrams was provided with the terms of reference, as I recall from the inception and the rules of this inquiry. If he had information that he thought was germane to this inquiry, he was very welcome to come forward. The other difficulty is Advocate Jiba was a Deputy National Director of Public Prosecutions in charge of almost all the prosecutions under the leadership of Advocate Mr. Abrams. It is almost, it would hamstrung any inquiry that you make into Advocate Jiba and Advocate Mokgoro if you sought to struck out Mr. Abrams' name from everything that appears on the record.
May I just do a short reply with your leave?
Okay.
The objection is very simple and quite fundamental. Mr. Abrams would have been aware of the rules and the establishment of this commission of inquiry, but he would not, because it wasn't drawn to his attention timeously at all, what certain allegations there are against him, which would have given him an opportunity to respond to them. I in fact have not, we have not in fact moved for the allegations concerning him to be struck out. The panel will obviously decide on the weight of Mr. Hofmeyer's evidence about these matters. The objection was, and the question was, why was Mr. Abrams not shown Mr. Hofmeyer's affidavit, which was some time after the rules were published? Why was he not invited to respond to them? And it was his election to do so. And he clearly wasn't. It's just a fundamental rule of fairness.
Now, can I say, in view of the background that you've just given, Ms. Bauer, the nature of these proceedings, the mandate of this inquiry, and the fact of public information being in public already or not, can we, and the risks that you have indicated, Mr. Arendse, can the evidence leaders and the lawyers come together within these 10 minutes and determine against that background whether you would, or rather what you would want to do? What agreement can you reach as to whether you expulse the evidence from the affidavits or not? And then we will hear what you agree or what you would want to do. If you can't come to an agreement, then we will have to make a ruling. Can you get together within these 10 minutes? And then we will adjourn for 10 minutes and come back to you. Yeah.
I raised the issue of striking off. The other one, of course, is sending a letter to Mr. Abrams with a copy of the affidavit with an invitation to respond either by affidavit or in person. That's the other suggestion. So, thank you.
Yeah. Just get an agreement between you two within these 10 minutes, and then we'll come back. Okay?
they don't even finish it. They cannot take it back. So it's kind of like, I think they fear that they allow people to do this like, you know how other commissions do it. If they all go back, you have to be there if they want. There's not even Wi-Fi, but at the same time I'm not complaining because seven at the end of the day, they lost start packing. And it's just December, so it's already struggling in December week. That's fine.
One day I was working for my snack. Just wait, just wait. And look for the car.
That was me yesterday. I couldn't find it. Like, when you see, okay,
Just there. Look just there.
yeah,
Just sometimes.
you know about that lady, this is boring. Yeah, I have come. And after the wedding,
Then there's watching running around the house. And then laughing in the corner. Then when they keep it, it's very hard. Then they run out and put these things back together. They're sitting there. I think that's how it's
yeah.
Sharon has tour dates. They will show South Africa.
One just hope to be here.
Yeah, and even big concerts. Even the concerts page doesn't have South Africa. People are messaging the concerts.
So even if I feel like Pretoria, they want to come through again.
That's what I'm saying.
But I mean, if it's like a major international artist, you still get those. Yeah, I think yeah. Well, I was asking you what do you get? Yeah, they were for free. But actually, I did get the free one. I actually enjoyed how it's fun. So I actually asked them once it's coming in the country. I am not. I started around 12 midday, and my last one was at 10 evening. And then I was like, okay. I was like, okay, everybody. I had got up with the nice thing. Nice to cater for alcohol, drinks, yeah. But actually, this was actually wait. It's supposed to take them to design. No, you could actually see this. Well, I wasn't up in the top seats, but I actually.
Oh, you were in the stands. We wanted to be like
No, but I think the best of the concert experience is to see them. But I like them.
I think the only question
It's just if it was real disappointing.
is this our decision.
No, we've been a fight about it. You didn't think so.
There he is. I think if you can just have it.
because we chose to be sweet and patient.
I enjoyed it.
choice now. They did admire the me. Yes. So if she messes up this show, and that's what my reputation is key after test.
She has a strong fan base.
Yeah, so I don't think she messes up because it's the three of us.
He exposed her. Oh, right in the situation. It's not that it's all other people came up with the evidence for what she stole the tracks. She didn't pay her back.
What's the fun is already?
So what I'm saying is I don't like
Okay, but she is correct. They are so right. That's what I'm saying.
We're trying to get it for you now. They didn't need to use classic. It's based on like she's not.
Well, she's kind of like a dip. She's tough. She's sold. She gets tough. She gets
there was a specific phase. Maybe 2000. Yeah. That's when we started. And now 21 years.
Are you going? Well, they sold
I'm
out.
sure you could get one. So,
Yeah. Okay, so what happens then? So Enquiry is performing and then?
yeah.
You're gonna have to give that.
I'm someone that is grateful to have made Tony a great match. What are you talking about? The fact that Tony. But he was not great as well. He was also
It was better.
yeah, but then I don't think they should bring him back.
Wasn't as bad.
Yeah, Tony is what's more funny is that
Every single country. Every single country.
Justice Bank.
No, I mean, to survive, so it's a resilient being physically don't know how. I think that's previous to okay, so
Rushed for nothing. Yeah, panicking and dying and thinking.
I think you almost came in here running. You had to cover some.
Is that 12 kilograms of paper?
Yeah, but it's right. It always happens. You rush in and then suddenly people are like, no, wait.
And we are not rushing because we know that the always be delayed. They started 5 minutes before. Or exactly on time. Exactly on time.
I've got a towel.
Yes, you need to put the time on it. Yes.
what about this one? There's the guy in this one.
He wants billions.
And you're printing like your furniture.
So what does he want? He wants to manipulate.
I think he was SABC, but I think he's
Malaysia make a like the colors.
Okay, but what if he has to free of
so to give him 50 million. It means something, and now it's
but it's too expensive. I've never actually seen it.
yeah, he bought it. But it wasn't his idea. It wasn't
It is not part of his daily duties or
No,
whatever.
it wasn't.
So it's kind of like I work for SABC now, and I can apply the ideas on the side to say, hey guys, this can help you get it, you can take it, and then that's it. And they just say, are you our employees?
It's still not enough.
Do you see Advocate Ramo when you look at me like this is the problem?
You're on my team.
But I mean, when you say that back in the day, it was this company was a part of this company, but was the case, it was at the Beyonce of the world. So they should cut the metal bench, right? Then bought it from yeah, revolutionary idea like nobody, you know what, right now, inside. that take half of it? I mean, why do you have to eat
I mean, I think you should accept it.
Do you know how expensive that damn data is?
I've started doing data.
I think I'm very with them. Well, what is I just pay the top up. About this? Where did you get this from?
Do you know Funkhouse's joke? Bye. Go listen to Funkhouse's joke. I've got to put it on there because it's a joke.
One day.
Thank you. The panel has deliberated on the submissions from the evidence, the parties, counsel, and the evidence leaders. We've also considered the notion that the two sides could not get to an agreement as to how to deal with this matter. And we have given it consideration and have decided to rule and give a directive that we proceed with the evidence of the witness. We proceed with cross-examination and re-examination. And we direct that the evidence leaders, led by Ms. Bauer, write a letter to Mr. Abrams, bring to his attention the proceedings of today, and invite him to make submissions and or come forward to give evidence if he so decides. And we will then take it from there.
As pleases, Madam Chair, does that include providing evidence via affidavit or simply oral evidence?
We would prefer that he does it probably affidavit and come forward with the oral evidence. Yeah. I think we'll look at his affidavit and see to what extent he puts evidence forward. And we should always be open to him giving oral evidence if he chooses to do that. But we prefer that he starts with an affidavit.
We'll attend to that today.
Thank you. Thank you.
Madam Chair, maybe before Mr. Hofmeyer swears in, may I also place on record and apologize to my colleagues. There is an affidavit of Advocate Jiba on record in the 17782, but there is also another affidavit which we have omitted to place in the dot box, which Advocate Fergus has now provided to us and which we will include in the evidence.
Please state your full names for the purpose of the record.
William Andrew Hofmeyer.
Will you take an oath or affirmation?
Take the oath.
Do you swear that the evidence that you shall give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Morning, Mr. Hofmeyer.
Morning.
What we have before this inquiry is essentially 3 affidavits which you had done. The most recent one on the 24th, commissioned on the 24th of January 2019, and the other 2 affidavits, one was commissioned on the 31st of March 2015 in the High Court matter of the Democratic Alliance versus the Acting National Director of Public Prosecutions in case number 19577. And the third affidavit is an affidavit which was submitted to the court in case number 1778215 in the High Court before the Lamo J, and that was dated on the 30th of January 2016. Is that correct?
That's correct.
Right. So let's deal with the genesis and before we deal with the substance of the affidavits, we'll deal with how they came about. But maybe before we even go there, let me ask you about yourself a little bit before I take you to your affidavits. You've set it out in the introduction of your most recent affidavit. You are currently a Deputy National Director of Public Prosecutions in the NPA. That's correct?
That's correct.
You had started in the NPA 1999 and was involved in the establishment of the Asset Forfeiture Unit, which you effectively headed until 2015.
That's correct.
You are currently the head of the Legal Affairs Division.
Correct.
Correct? And you headed up the Special Investigating Unit from 2001 to 2011.
Correct.
And I understand that a Deputy National Director of Public Prosecutions who heads up the SIU wears dual hats. Is that correct?
I didn't head it up in my capacity as a Deputy National Director. I just had 2 jobs for the price of one. So I was both appointed as head of the SIU in terms of the SIU Act, and at the same time I remained a Deputy National Director.
What is not in your affidavit is when did you get appointed as a Deputy National Director of Public Prosecutions?
I think it was about 2001, but I'd have to verify that.
Okay, was this at the time when Mr. Ngoku was still the
Yeah.
NDPP? Right. And you were approached to provide evidence germane to the terms of reference, correct?
Correct?
And you had then prepared this affidavit.
Correct.
So that's the most recent affidavit. But let me take you back to the affidavit which was done in case number 17782. This was in the High Court in the Western Cape, correct?
Correct.
And explain to us the circumstances as to how this affidavit got to be admitted. Got to be, let me rephrase that. It got to be, you put it forward, prepared.
I'm not going to go extensively into the background, but there was a matter brought to court in the Western Cape by the Democratic Alliance. In the answering affidavit prepared by the NPA, the then NDPP, Mr. Abrams, made a number of allegations against me and Mr. Ngasana. We took legal advice at the time, and we were advised that we should seek to interpose to correct the record. I think our attempt was unsuccessful in the end.
And the judgment of the Lamo J makes no mention, in fact, of either the affidavits being sought to be admitted or his ruling at the time that they would not be admitted. Is that correct?
Yeah, as far as I understand.
And as I understand how it played off was you sought to have these affidavits admitted. Advocate Jiba filed a response to it, but ultimately they were not regarded by the judge as being admitted. Correct?
Correct.
And in fact, I haven't looked at the judgment right now, but my recollection is Advocate Delamo dismissed the application in the Western Cape High Court or we can deal with the reasons later. Correct?
Correct.
Your other affidavit, which was filed in the Gauteng matter, on whose behalf did you file that affidavit?
I filed that on behalf of the NPA.
And in fact, on that occasion, you were authorized by the then acting National Director of Public Prosecutions, who was who? 2015.
I think it was Ngasana at the time.
Right. And the head of the Director of Special Operations, which wouldn't have existed at that stage anymore.
It was just in the name of the litigation. There was
Yeah.
no head of operations anymore.
Right. Now, I'm going to first deal with your more recent affidavit, and then I'm going to go through parts of your other affidavits. You point out, based on your experience, that you are familiar with the workings of the NPA, the SAPs, the Scorpions, and the Hawks. Is that correct?
That's correct.
Right. You point out in paragraph 8 that despite having serious ethical issues that you raise in this affidavit, and I want to come back to your differences and issues, but let's deal with the second part of that. We'll deal with that in more detail. In the main, you had a good working relationship with Advocate Jiba as a fellow DNDPP, fellow DN, I'm going to get this wrong, but let's just call it as a fellow deputy, and when she was acting director, correct?
That's correct.
Do you want to elaborate on that?
Not in great detail, but I suppose we went through an era when Menzi Simelane had been the NDPP, and I think many of us were pretty discontented during that period, and I think when Advocate Jiba was appointed to act, it was a bit of like a breath of fresh air in the NPA at that time.
And why do you say that?
I think there was just a lot more collective leadership. She consulted with her deputy, well, her fellow deputy nationals, I suppose, at that time. But yeah, we just felt that our inputs were valued and that we could make a meaningful contribution to the NPA.
But you then go on and you say you have serious concerns about her fitness for high office, and we'll deal with that. So we're going to come back to your concerns about serious ethical issues, your serious differences, and your serious concerns about her fitness for high office. You do say that she was a capable manager when she was in charge, and she was able to get the team to work well together. Could you elaborate on that?
I think I tried to cover it in what I said previously, but we did have a lot, much more of a collective leadership in the NPA at the time. I think me, my fellow deputies, the DVPs all felt that they were being consulted and their views valued a lot more than they had been before.
Can I apologize? I'm always being made the choir master in this place.
More volume.
Can I point out I'm on day 9 now?
Yes, kindly. Yeah, we all need to hear you, Mr. Hofmeyer.
Though you say that you have a qualification in paragraph 10, can you elaborate on that qualification?
I think I deal with it a bit more later in my affidavit, but I'm referring amongst others to the Boyson's case that was sort of done in a great deal of secrecy and where we were not consulted about the matter.
And effectively, you say that there was, in some of the controversial matters, you had not been that form part of the subject matter, you had not been included, didn't have knowledge of what happened until you heard about it from others in the NPA or until it was reported in the media.
That's correct.
Right.
Can I sound very stupid, Ms. Bauer? Which affidavit, which pages are we at?
I am in the affidavit to which he deposed to most recently, which is January 2019, and we are currently in your file. You are on page 449 is where the affidavit starts, and I'm probably on 450 at paragraph 10. Are you? Right. I'm going to not take you specifically to what you say in paragraphs 14 and 15, but would it be sufficient to say that effectively there had been no stability in this organization since its inception in relation to leadership? And that I mean the National Director of Public Prosecutions.
I think that is broadly the position. As I do say that Pulelani Ngcuka was the first NDPP, I think we had considerable stability at that time, but it started falling apart, well, for the first 3 or 4 years, but it started falling apart after that.
You then discuss your current position at the head of LAD and perhaps elaborate on that, and maybe I should place on the record that paragraphs 18 to 27 are the paragraphs which my learned friends have indicated they have difficulty with. But for purposes of this advocate, Mr. Hofmeyer, maybe explain how your position in LAD came about and what your role was.
So I had up till that time been head of the asset forfeiture unit, and I think we had operated with a great deal of success. Mr. Abrams, when he was appointed, made it clear that he, not immediately on his appointment, but a couple of months afterwards, that he wanted to reallocate the deputy nationals to different positions, which is his prerogative to do. I cannot dispute that.
I maybe at that point interrupt you. Do you, have a Deputy National Director of Public Prosecutions, have any expectations as to what tasks or legitimate expectations or any expectations of any kind as to what tasks the National Director assigns to you?
I think legally speaking, we probably don't have a case on which we could go to court. I think as a senior manager in the NPA, I would expect to be utilized in an area where I have expertise and where I can make a difference to the crime situation in South Africa, which I think I had achieved as head of the asset forfeiture unit. But as I say, I don't think I did explore the possibility of a legal challenge at the time, but it was clear. I think the law is pretty clear that the National Director can move us around without any need to either consult or without legal recourse for us.
And can a minister or president interfere in that process?
I would suggest not. Initially, when we were appointed as when I was, for example, appointed as Deputy National, the motivation for me to become a Deputy National was specifically to be in charge of the asset forfeiture unit. And I think similarly, my other colleagues at the time were appointed to sort of specific responsibility, head of prosecutions and head of, I think the head of the Scorpions, when it was part of the NPA, was also Deputy National Director.
Sorry, I interrupted you. Continue.
Sort of beyond the Deputy National?
No. You were busy explaining your removal from the asset forfeiture unit at the behest of, it's Mr. Abrams, eh?
Yeah.
It's not Advocate Abrams. It's
Yes,
Mr. Abrams.
but I always thought the council are called Mr. too. But
Well, I've been scrupulous in doing that. So you were explaining you were removed from the asset forfeiture unit and you were made the head of LAD.
Yeah, so I mean, my objection to it essentially was that it was not an area of law that I was well qualified in. When I did my articles many years ago, I did mostly public interest law cases at the time, but it included one civil claim, but that was all that I had done in my life previously. I did have some skill in dealing with public interest litigation, the sort of urgent applications that were brought against the NPA when things were going wrong. But those applications were all removed from my control as well and allocated to some of the staff members in LAD who worked directly with Mr. Abrams and some of the staff in his office on those cases.
And you make mention that the lawyers on the LAD who worked directly in that regard was one Tobile Chita, and you refer to who the personal advisor and the previous head of the OWP in the office of Mr. Abrams, correct?
Yeah. As far as I could ascertain, I mean, I'm not, Mr. Voller and Mr. Adam was in the National Director's office, so they reported to him directly. But they seem to deal with those applications separately from my control and supervision.
And when you say your control and supervision, you point out in paragraph 22 that there was no reporting line to you, even though you were the head of LAD.
Indeed. Oh, sorry.
And you had a belief as to why you were put into that position.
I mean, the inference that I drew, because these were mainly around certain contentious cases, is that the NPA were perhaps not wanting to be as forthright in its responses as it is legally obliged to do, and that they were looking for people who would either not disclose certain things or perhaps massage the truth. I mean, I can't say because I've never, definitely, because I've only became aware of some of the cases afterwards.
And on what did you base that, Mr. Hofmeyer?
I mean, I can give one example, for instance, that isn't in my affidavit. So I'm not sure if the inquiry is familiar with the notion of grabbers, which are mobile interception devices used for unlawful interception of mobile phones. So a very large 26 million rand grabber that had been purchased by a Free State farmer on the instruction of an official in the Department of Public Service and Administration was seized by the police, and the farmer brought an application to have his grabber returned to him. But that case was removed from me almost immediately, and as far as I can gather, the case was never litigated, but the unlawful device was returned to those who were the owners of it.
Okay, I don't understand what a grabber is. Maybe for purposes of clarification, you explain what a grabber is.
So a grabber can vary from a grabber is essentially a technical instrument that intercepts the signal between your telephone and the nearest cell phone tower. In fact, it sort of substitutes itself as a cell phone tower. So it misleads your phone to think that its calls should come through it, and then the calls can be recorded. And obviously that is done without any judicial authorization and so on, as is usually required for interception of telephonic communications. So it was used, I first came across it, I think at the time of the Celebi case, when the head of crime intelligence was using grabbers to spy on the NPA and on the team prosecuting Celebi. That's the first time I kind of became aware of it. But I think since then it has been sort of systematically used to spy on lots of different people and not just those in law enforcement.
And is the device used by private people, or does the state use grabbers?
I mean, mainly as far, so initially my understanding is that grabbers are useful in the sense of being able to locate a cell phone with some precision. So if you're looking for some CIT robbers and you want to try and find them, and you can get close enough to them, then the grabber can be used to get pretty, a very good idea of where exactly they are.
What I want to know is whether they're freely available.
As far as I
in private
understand,
sector.
they are unlawful to possess.
They are unlawful. They're unlawful to use.
Yeah. I think that maybe parts of the intelligence establishment may have been formally authorized to acquire them. But the problem is normally when you want to intercept cell phone communications, there's a formal process to go through it, and there's various institutions that check that your interception of communications is being lawfully done and for the correct purpose, and it's for a valid law enforcement use. I think grabbers end up being used to spy on political opponents. It gets used to spy on people in law enforcement who may be investigating the wrong people. But I think essentially it gets used unlawfully and is abused.
Before we get sidetracked, the only point you were trying to make is that a civil application was being brought for this grabber to be returned to this farmer in the Free State, and that application was removed from you.
Yeah.
And who was in charge of prosecutions at the time, and who was the director?
I have not heard. I believe prosecutors in the DPP office in Pretoria did get to know about this case and was interested in prosecuting it. But as far as I'm aware, there was no prosecution that took place.
Was Advocate Jiba or Advocate Mokgoro involved in this, to your knowledge, in any way?
Not as far as I'm aware.
You then, in your affidavit, deal with the creation of the NPA and the NPA Act, which you then set out your nature of your involvement. And there's only one aspect that I want to touch on in that regard. It is essentially the structure of the creation of a central office of an NDPP and a, shall we call it, DPP office based at a high court. And maybe you could just explain what was the objective sought to be achieved by a structure designed like that in our Constitution and its genesis.
Yeah. So, Chair, I'll talk to section F of my affidavit from paragraph 51 onwards. I was a sort of member of the Constitutional Assembly that drafted the Constitution. I chaired the committee that wrote the chapter in the Constitution dealing with the NPA and the judiciary. In the negotiations around the Constitution, there was a huge amount of dispute about whether there would be a single national head of the NPA with full powers and what the implications would be for the then Attorneys General, or what we now know as DPPs in the provinces. And it was one of the last issues to be resolved in the constitutional negotiations. The resolution at the end was that the original powers to prosecute would remain with the DPPs in their jurisdictions, which wasn't quite provinces at that time. And that the NDPP would essentially have a sort of policy-making oversight role, and that's why the law also later provides that the NDPP can review a decision by the DPP, but it is through a formal process, a process that is essentially, so an accused person or even a member of the public can ask for a decision to be reviewed. But it is through a process that essentially is paper-based. It is discussed, there's correspondence, there's motivations, and the courts have held that those documents can be obtained for the purpose of litigation. So in many ways that is a pretty transparent process. There is one part of the Act which has sometimes confused some of the NDPPs, which provides that an NDPP can, in person, go and prosecute a case. I don't think it's ever happened in the history of the NPA, or one or two NDPPs had considered it, but sort of shrunk back a bit when they realized how much work it's going to be and how much time it's going to take. So I think the second part of the discussion that I just want to alert you to is in section G, where it talks about the directors and special directors of public prosecutions. In this matter, Mr. Mokgoro is sort of one of those special directors, which is why it's relevant. So in the parliamentary process, we were able to persuade the opposition parties that despite the fact that we have DPPs with full jurisdiction, that in a complex economy, country, there is a need to deal with crime at the national level as well. Organized crime, huge corporate offenses, and so on. And for that, those offenses would usually span many jurisdictions, and it makes sense to have one place with somebody who can take charge of the investigation. So we took obviously serious legal advice at the time when we drafted those provisions, and that is essentially where the notion came from that a special director can be appointed, but he has to take all decisions in consultation with the DPP that has the power to prosecute in that jurisdiction. And if we did not provide for that in the Act, then those provisions would have been unconstitutional. So there is a sort of significant constitutional imperative behind that need to act in consultation with the DPP.
And that was because the Section 179 was drafted giving DPP's original powers.
Correct. There's one exception that I should mention, and that was at the time when we drafted the Act, there was already something called the Office for Serious Economic Offences, which was run, I think, by Jan Swanepoel at the time, but sort of investigated big corporate frauds and at that time not much corruption. But I think all the parties in Parliament agreed that the notion of what is called an investigating directorate is an important one to deal with big complex fraud. It's very much based on the model of the Serious Fraud Office in the UK, our original legislation around that. So where you have prosecutors and investigators working together as a team under a single line of command of the investigating director. So when Mr. Nguka became NDPP, he was very impressed with this model of what the Jan Swanepoel's outfit had done. And he started 2 more investigating directorates, I think one to deal with corruption that didn't really take off, and another to deal with organized crime, of which I think Percy Son was the first head. So by 2000, there were then essentially 3 investigating directorates operating. When President Mbeki was appointed, he wanted to do some big things to improve the capacity of law enforcement. And out of that engagement essentially came the idea then of the Scorpions, the Directorate for Special Operations, which essentially meant bringing those investigating directorates together in a single body. And the other change was that up to that stage, the investigators had been seconded from the SAPS. So the law relating to the Scorpions provided that the Scorpions itself could appoint investigators. And I think that is what made a huge difference, is that prosecutors and investigators working very closely, essentially under a single line of command. Because when there's different lines of command, things can go haywire pretty fast when you're dealing with those sort of big cases. So I'm sorry for spending a bit of time, but I think it's just important to understand that for the investigating directorates, the Act provided that they take prosecution decisions after consultation. So they only had to have a discussion with the DPP. And that was kind of agreed by everybody because there had already existed the Office for Serious Economic Offences that operated, and it was, everybody agreed that it should continue operating at the time. So, but that is why if you look at the Act, there are different provisions dealing with special directors and investigating directorates.
But besides the Act, Mr. Hofmeyer, if one looks at page 9 of your affidavit where you deal with the meaning of in consultation, would it be fair for me to say that it's the ABC of administrative law, the distinction between after consultation with and in consultation with?
I do think that it is very trite law and has been for a long time, but I do go on to mention that when we wrote the Constitution, these terms were used so often and that it was actually decided that there should be a formal definition which was in the interim Constitution of what in consultation and what after consultation means.
But even in the absence of a writing in the interim Constitution, there is a plethora of legal opinion which precedes the interim Constitution.
Indeed.
And posted, which makes it very trite as to precisely how and what these terms should mean.
That's correct.
And even so, if we go to what paragraph 75 of your affidavit deal with, and it refers to the minutes which is attached as annexure A to this affidavit. It came up in a discussion within the NPA executive meeting in January 2012. That is post the decision that had been taken by Advocate Mokgoro in relation to the Mluli prosecution, correct?
That's correct. And that's why I raised the issue at the meeting.
You raised the issue at the meeting. Is that?
Yeah, I think others also wanted to raise it. I'm not quite sure which of us spoke first, but I did have it on my list of issues that needed to be discussed.
and you had provided us both with the minutes of that meeting as well as your notes of what occurred at that meeting. Now, the proposition, without us going through it laborious, that I want to put to you, could there have been any doubt at the end of that meeting that any decision which was not taken with a consensus reached wasn't lawfully taken?
I don't think anybody could have come out of that meeting with a different understanding. I think there was a lot of discussions, but almost everybody agreed that that is the correct interpretation. And some people, not everybody spoke, so I can't quite say whether everybody agreed, but it was the outcome of the discussion that there was an agreement that is what it means.
And both Advocate Chiba and Advocate Mokgoro was present at that meeting.
That's correct.
And one sees that from the second page of the Annexure A, correct?
That's correct.
You then deal with the administration of the MPA and its accounting officer, and we had evidence from Advocate van Rensburg in relation thereto yesterday, so I'm not going to take you to that specifically. I want to take you to paragraph 94 onwards, and maybe I'll place on record that paragraphs 94 to 105 are also paragraphs in respect of which the my colleagues have raised an objection. But essentially, wouldn't you say it's fair to say that different managers have different management styles? Do you agree with that?
I agree.
You point out that there were different kinds of management meetings in the NPA to comply with state precepts, and that these happened on a monthly or quarterly basis. Could you perhaps elaborate on that?
I think around that period, there was a lot more emphasis in government on compliance with the PFMA, that there need to be formal meetings, minuted decisions, and I think that was part of the drive to really formalize structures in, the accountability structures in the state. I perhaps should just raise the one issue that you skipped over, and that is that the NPA did not have its own accounting officer. The DG of Justice was the accounting officer for the NPA. So we did, in some ways, have no real control over our administration, although over time the ministers of justice more or less had agreed that somebody in the NPA could be formally appointed to exercise the powers of the DG in the NPA. And so we got around those difficulties that many things had to go to the justice officers, wait for approval for long times and not happen.
Sorry, Mr. Hofmeyer, I skipped over it because we had Advocate Karen van Rensburg who testified to the role of the CEO yesterday, and yours is not much different to what she had to tell the inquiry. Moreover, she also pointed out that although there isn't a CEO currently, those powers have currently, as a matter stand now, been delegated to Advocate Ramaiti.
Yeah, we've just called it head of administration instead of CEO. I think that was the change.
So if we can then take you to I of your affidavit, there were essentially 3 layers at which meetings took place within the NPA. Maybe if you elaborated on that and specifically dealt with what we call, shall we call it the top management, being the NPA and NDPPs.
So let me just say that in terms of our formal structure, the ones that prescripts insist that we have, during most of this period we had what was called EXCO meetings in the format that is reflected in the minutes that's attached. So that included not just the NDPP and his deputies, the head of administration, but it also includes the DPPs from the different provinces, and also on occasion head of HR or head of finance, I think, was part of it for a lot of the time, because that is where many of the prescripts need to be implemented. In addition to that, at most times in the history of the NPA, we had less formal meetings. So the NDPP would meet with his or her deputies fairly regularly. At times we met literally every week. Not for long meetings, but just to catch up with what's happening, what's urgent, what the NDPP would like input from his or her deputies. So those were not formal meetings, not formally minuted, although we took sort of shorthand notes from those meetings. I think there was also a period when the EXCO that I described functioned without all the DPPs attending, and I think particularly when financial constraints happened at various stages and the cost of bringing everybody to one place was a real factor. But I think during most of this period, the formal EXCO meeting included the people that's described in the minutes there.
You have to be specific about what period you're referring to, because it spans a different time period, and the inquiry needs to be clear about when you say which period, the time frames you're referring to.
Chair, I started to do some digging on that just to try and find dates, and I ran out of time. I am willing, perhaps with Dr. Ramahita, just to do that work and to submit it to the committee urgently. But I don't want to testify about exact time periods, because I just wasn't able to find exact dates for those time frames.
Mr. Hofmeyer, I'm not asking you for exact time frame. Are you talking about the period in which Advocate Jiba was the acting National Director of Public Prosecutions, or are you talking about the period in which Mr. Abrams is the NDPP, or when Mr. Ksana is the period? I'm trying to place it within the context of the terms of reference of this inquiry.
I may stand to be corrected, but I think the structure I'm describing here functioned during the period that Advocate Jiba was NDPP. It may not have started immediately. I'm not quite sure of the starting date, but Simelane had basically stopped all. He didn't really want to operate in a collective. He wanted to engage with people individually. So it was a very liberating moment when we were at last able to meet together again regularly.
There were also meetings less formally with the deputy directors of national prosecutions with Advocate Jiba, as I understand it. And how regularly did that take place?
Again, I haven't quite been able to get my notes in place, but most of the national directors initially informally, if there's a big issue, would call in his or her deputy nationals to discuss, consult with them. So those are the meetings I mentioned that were informal. At times, and I think it was applicable during Advocate Jiba's tenure, we tried to meet every week on a Monday morning for a couple of hours. I just can't say how much of it happened. Those meetings often would get postponed or not happen if there's a specific things happening, but I think in that, those meetings happened fairly regularly during a term.
And you say in paragraph 102, you kept notes of those meetings?
That's correct.
And maybe I place on record that you didn't provide this inquiry with those notes? Is that correct?
Only in the one place where I quote the notes I took it. Yeah, no, I didn't. At most of those times we didn't have our computers with us, and so my handwritten notes are very cryptic about those meetings where they exist. But if the inquiry is interested, I can make an effort to get more detailed notes.
The purpose of the request to you, Mr. Hofmeyer, was to ask you whether any of those notes had relevance to the terms of reference of the inquiry. And you would have needed to make an assessment of that. Isn't that correct?
Yeah.
And you had not provided the inquiry with any of those notes?
I just didn't get very far into the notes, I'm afraid. I have added, I have included the one set, but actually those were notes I took at the EXCO meeting rather than at the Deputy Nationals meeting.
During the time you say those meetings were held when matters were to be discussed, to the best of your recollection, were the cases which formed the main subject matter of this inquiry discussed at those meetings? Shall we take them one by one? The Boyson matter.
The Boyson matter seems to have been handled in a great deal of secrecy at the time. So we did learn about it, but only after it seems to have been on the go for a while. So I was in meetings where it was discussed, but sort of after it emerged in the public domain as far as my recollection goes.
So are you saying that the decisions taken in the respect of the Boyson matter was not decisions which emanated from these meetings?
And let me say that it's not that the decisions need to emanate from these meetings, but the practice in the NPA has been that they are big, if there are big important cases that have significant implications, that the NDPP would discuss that with his or her deputies. That didn't happen in this case, whether in a formal meeting or informally.
There was, besides the Boyson matter, there was also the freedom under the law matter, which would have arisen sometime in mid-2012. Let me precede that question with another question. The decisions which was taken by Advocate Mokgoro in December 2011 certainly came to your attention because Advocate Breitenbach and Advocate Ferreira testified that they had provided you with a copy of the memorandum.
Indeed.
So you were aware of it by April 2012?
Yeah, I mean, I was aware of the crime intelligence investigations generally. The asset forfeiture unit had actually obtained some freezing orders, not in relation to Mdluli specifically. So I was aware of the allegations and the investigation, but I was not part of any decision-making process about that.
Was the memorandum provided by Advocate Breitenbach and Advocate Ferreira discussed at EXCO level?
I've been trying to see if I can find some notes, but I don't have a recollection of it being, I mean, it was discussed, but I don't think at a sort of at the formal EXCO level as far as I remember.
Subsequent thereto came the application brought by Freedom Under the Law. What do you recall in respect of the involvement of the EXCO in relation to that application?
Again, I cannot say that that I'd been significantly involved in the discussions around that. I don't know to what extent others may have been.
Do you have any recollection being part of an EXCO meeting at which decisions in respect of that were taken?
Before the application was brought?
After the application was brought?
Yes, I do think that I were part of discussions, but I don't have the details.
We then come to J, and you will recall that there were 3 general statements made at the start of your affidavit that I said we would come back to, and that related to your reservations about Advocates Jiba and Mokgoro fitness to hold office. And you deal with this under J.
That's correct.
Right. And I'm going to deal with this in conjunction with your affidavit which you made in the Gauteng matter, which is the 2015 affidavit in case number 19577. And I want to take you to specifically page 156 of that affidavit, starting at paragraph 410. Mine says page 156. It's the Hofmeyer affidavit of 31 March 2015. The affidavit starts on the index at page 91.
On the paginated document?
Sorry, I'm assuming it's the top right-hand corner pagination. So the affidavit starts at page 91, and I'm taking you to page 156.
Okay.
And at the bottom of page 156, you would see warrant for Gary Nell's arrest, starting at paragraph 410.
It starts at 91, then it gets lost. 156.
Yeah.
Apologize, my papers are numbered differently.
203. 203.
Mine was renumbered, but it's on 203.
My apologies, maybe the thing is I've prepped witnesses before numbering got done, so my numbering might be a bit out. Can we just go to paragraph 410 of the affidavit, and maybe I'd best guide the inquiry with references to paragraph numbers.
Warrant for Gary Nell's arrest.
Yes.
203.
For record purposes, it would be page 203. Advocate Hofmeyer, you could briefly give us, I didn't take you specifically to the paragraphs leading up to that point, but maybe for a context, you can explain that to the inquiry.
Just to remind you, I'm just a mister, not an advocate. The Celebi investigation sort of precipitated a major crisis in the NPA, I think, as everybody is aware, and led to the removal of, or the suspension and then removal of Fusi Pikoli as NDPP. So there was a significant amount of political interference. We were particularly obstructed by people in crime intelligence, but also some of the other intelligence agencies. And I think the sort of broader concern that we developed at the time is that people in the NPA were collaborating with those outside the NPA to try and ensure that the prosecution didn't happen. So the episode I'm talking about happens, my dates are right, early 2008, I think. So what you see in the preceding paragraphs is some information about the attempts by the intelligence community to turn Agliotti, basically. They make him certain promises. He gets taken to a hotel, Villa Via, I think that's on the hill there in Pretoria, opposite the Union Buildings, where essentially they, through various inducements, persuade him to change his version. And they make a video and an audio recording of him doing that. So what then happens is we do get some idea of what's going on. But essentially the sort of the Christmas period intervenes and everybody goes on holiday. So the arrest of Nel happens on the day that he comes back from holiday. It's clear that by then Celebi had prepared an urgent application for the permanent stay of his prosecution. And that the idea basically is that while Gerry is in jail and unable to help, the urgent application would go to court, and they were also denying bail to Nel at the time.
So in that context, just to put it in context, Gerry Nel is the prosecutor in the Celebi matter.
He's the lead prosecutor, yeah. So what essentially happens is that when we received the urgent application, which I think was set down at very short notice in court, and we worked through a night or two to try and put the papers together. But in the application there were, I think, the documents that the Commission have, but the statements made by Ms. Jiba and Ms. Mokgoro in support of the investigation, essentially.
You need to be clear precisely what you are referring to in that regard, Advocate Mr. Hofmeyer, and maybe take us. We're on 156, 157. You've dealt with the part which deals with what happens when Mr. Nel is arrested. But maybe take us back to what happens prior to Mr. Nel being arrested. And I'm referring to what is contained in your affidavit from paragraph 411 onwards in the 2015 application.
So, sorry, you want me to talk about these paragraphs rather than what preceded? I think a lot of the detail I set out there, but essentially apart from Ms. Jiba and Mr. Mokgoro, another senior official of the NPA, Mr. Mokotedi, who is the head of our, somewhat ironically, the head of our integrity management unit, seems to have played the major role at that time. And we don't quite know how things unfolded, but he very much regarded himself as a personal friend of Mr. Salebi, and seems to have been integrally involved in putting together the collaboration from the NPA side with the police.
Right. Now, the arrest of Gerry Nel related to specific charges which you deal with in paragraph 417, and specifically tell us what that related to and how is that germane to this inquiry.
I think it is, it initially arises, you know, the issues arise partly out of the investigation into Cornwall Chavunga, who was a senior Scorpions prosecutor at the time. And in the, okay, there are a couple of angles. In the course of the judgment, the judge had, or the magistrate had criticized Nel for not having exercised sufficient control and managed him sufficiently. And it seems that this was then used as a way of launching a sort of police investigation into Nel. I think the other angle that happens at the time is that Advocate Jiba's husband is convicted of fraud on his trust account, and that seems to have, and let me say, I didn't really know her much at that time. I sort of got to know her better when she was the Deputy National. But it seems that she had a bit of a grudge against Nel at that time because of that.
And what do you base that on, Advocate Hofmeyer?
I think I mean, part of the affidavits that I attached here from other persons who sort of contributed to the subsequent investigation of what happened, I think that they allude to the fact that she seems to have a dislike for Nel.
Can you be specific of what affidavit you're referring to?
I haven't looked at the references to those in terms of speaking to it here. Can we come back to that point?
Can I, while we're at this, can I direct you to page WH 188 and ask you whether that's what you're referring to? Because your affidavit is footnoted. Page 431.
Thank you.
Can you identify that document?
I've got the document. I'm just looking at it. Oh, sorry. It's a sworn statement by Vernon Nemo Orani, who was one of the people that was approached to assist with obtaining a warrant for Nel's arrest.
And why was reliance placed on this affidavit in the context? Perhaps give the inquiry the gist of what's in that affidavit.
I think what's the main part...
Sorry, Mr. Hofmeyer. I don't want to lead you into this. I had asked you the question. You had made the proposition that you had concluded, and I don't want to rephrase what you said, you made the statement in your affidavit that Advocate Jiba had disliked Nell, and you had explained what had happened to her husband.
So if you look at page 440 at the top in Namorani's statement,
Give us the paragraph number.
it's paragraph 41. It says, it's always been clear to me that Advocate Jiba had a score to settle with Nell.
And does the affidavit explain why she says that? Why he says that?
So if you go back to paragraph 24 of the affidavit, he says that from the beginning of September 07, Jiba had consistently talked about the fact that they are working on something and it will happen soon. Although she was never specific on what would happen, she mentioned that it relates to Advocate Nell. She mentioned meetings with people held from the Presidency, the Department of Justice, and members of SABC. According to her, meetings were held even late at night.
Can I refer you to paragraph 16, 17 onwards of that affidavit? It links back to your affidavit where you explain in 420 and to which you footnoted paragraphs 13 to 20 of this affidavit.
Malady,
Yes, Mr. Aronson.
may I object to this line of questioning? This is a witness giving hearsay evidence. Now, to make it worse, the evidence leader now directs him to an affidavit which is before this commission. I don't know whether the evidence leader has inquired whether the deponent is alive, willing and able to testify to this directly, to this commission of inquiry. Why would we want to hear this through the mouth of Mr. Hofmeyer? He's got no direct knowledge of any of these events.
The proposition was put to, so let me place the first thing. The deponent of that affidavit has refused to assist this inquiry in the first instance. So it wasn't that we didn't make a request of it. Secondly, there is no rule that hearsay evidence is not admissible. The proposition which was put to Mr. Hofmeyer was, in his affidavit, he had reached a conclusion. I asked him on what he based that conclusion. He said to me he needed assistance to get to where he came from. I directed him to the portion based on a footnote in his affidavit. Now we can either let Mr. Hofmeyer explain how he came to that conclusion and find his own paragraphs, or I can assist him. If you look at his affidavit at paragraph 420, footnote 116 refers back to that affidavit.
In other words, you're trying to link that evidence to the evidence that Mr.
Hofmeyer is giving. I'm not disputing that
That's
it's
how I
hearsay
understand
evidence, and I'm not disputing that you must place whatever weight you put to hearsay evidence. I'm actually saying that there is no impediment to hearsay evidence being put to the inquiry.
Particularly if you're trying to link, and the question will be, can you see the link? And I would rule that we continue with this. We will determine it.
My lady, we obviously respect that ruling, but by the evidence leader and Mr. Hofmeyer's own admission, it's a conclusion that he has drawn from what someone else has said. It doesn't make it valid, and it doesn't make it admissible. I am astonished to hear that hearsay evidence would be admissible as a matter of course. We know that that is not what the law is. Section 3 of the Law of Evidence Act, I think the amendment, provides for what the requirements are for whether or not hearsay evidence is admissible. What I don't think we would object to cut through all of this, is for Ms. Bauer to say there is an affidavit before us, because we've already agreed in terms of the rules that all the paper, all the evidence, all that's before you, we'll argue that at the end. But now for atmosphere, for the media, you want Hofmeyer to come and tell us what happened during the saga when Gerrie Nel was arrested, when he's got no knowledge of it whatsoever. It's not fair, my lady.
With respect,
See the link. We would like to see you make the link.
I do take umbrage at the insinuation that this is being done for media atmosphere. I have done my utmost in accommodating my colleagues in respect of not leading evidence directly, specifically for that reason. And I think it's important in respect of the challenges that's being made against this witness evidence, that those links be shown to the inquiry as to what this witness's views are. I'm not elevating it to higher than that.
We also do not understand Mr. Arons's statement to say you are leading this evidence for the media. I don't think that's what he's saying. But we would like to see the link that you make, and we would say you proceed with leading the evidence and make that link.
Can I confirm something, please? This affidavit is filed as an annexure, would I be correct, as an annexure to WH 187?
Ma'am, sorry to interrupt. There's quite a bit of noise coming from the kitchen as well, and we really can't hear what you are saying, especially Judge Mokgoro.
Tell the choir master and she will make sure it's done.
And I think my age is also giving me away. But between all of these factors, I'm struggling to hear what the panel is saying. Sorry, ma'am.
Okay. I will try to do better. Okay.
As I said, talk to the choir master. I'm not sure why I'm the only one who talks loudly. It's probably because of my age difficulties. Page WH1.
Before you do that, can you just get a message to the kitchen to try and manage the cleaning of... we understand that they have to prepare for lunch, and unfortunately we had to use this venue for a number of reasons. We will just have to manage the noise. Thank you.
I just wanted to understand the link.
I am leading the witness on the evidence which he provided in an affidavit which he made in 2015. He draws certain conclusions in that affidavit. I asked him the basis upon...
No, I'm not querying it. I'm just saying, was this affidavit annexed to this? That's all I wanted to know.
Yes.
If it's not, it's not.
So you would see to this affidavit, pages WH1 onwards is annexures to that affidavit.
I need to place it on record. Remember, I've been saying to you, and I know you're tired, get your identified documents, and it helps. That's all I was saying.
So essentially, Mr. Hofmeyer, for purposes of where I was taking you, I'm essentially trying to make the link between the persons who's the subject matter of this inquiry to the Gerrie Nel arrest. And in the course of doing so, I'm taking you through the paragraphs in your affidavit which you deposed to. I put to you a proposition that you had put in your affidavit that Advocate Jiba had disliked Advocate Nel. You premised that on other statements, and I then took you to a statement which you find on WH 188 and specifically referred you to paragraphs 13 to 20. Now, I don't need you to read this in the record. I'm trying to ascertain, without us having to give you a time off to go and look at what you base that on, whether it was this statement upon which you premised the conclusion you reached in that affidavit.
Chair, I
Think
think
you may
it may speed things up a bit if I can be allowed, if we maybe take our lunch earlier and I can try and identify specific paragraphs, because I have not done that up to now. But what I can say in relation to the situation at the time is that essentially I had de facto started managing that investigation after Leonard McCarthy left. So I was very involved in the day-to-day meetings with the investigating team, helping them to deal with the difficulties, both around the attempts to recruit Agliati with the urgent application that came to court. So what I wasn't involved in was the detail of what was said in each affidavit. I mean, I've read them all at the time, and I've read them since. But I can't, off the top of my head here, start pointing to paragraphs. If the commission would, or the inquiry would like me to cite specific paragraphs, I would like maybe some time just to go and identify that, rather than us wasting time trying to find paragraphs that should be easy to find, but not in a big meeting.
Would that serve you better?
No, I think the witness is misunderstanding my questioning, but let me go to another line of questioning, and then the witness can have time during the lunch adjournment to deal with it, and I'll come back to this.
My lady, if it may help, and also to save time. Mr. Hoffmeyer's evidence is that he understood that Ms. Jiba allegedly did what she did because she disliked Gerrie Nel. He's got no personal knowledge of this or experience of this, but there is someone who appears to have had, and who says so in another affidavit that's attached to my affidavit. And leave it there, and we must make of it what we do, and when I cross-examine him, let's see if we go there, if we need to go there.
Happy to deal with that on the dislike question on that basis, and Mr. Hoffmeyer can then look at those allegations in relation to
So you will alter your line of questioning.
I'm going to proceed from that point, right?
Thank you.
Right. Essentially, the evidence at the disposal of the NPA, which you then describe in your 2015 affidavit, and which you then detail in somewhat in your 2019 affidavit, is that in essence Advocate Jiba was involved in effectively securing the arrest of Advocate Gerrie Nel.
Indeed.
And what was that based on?
I think the dislike may have played a role, but my sense was that for whatever, I suspect, politically motivated reasons, they had decided to help the police with this investigation. I mean, Mokgoro, I think, makes his own position a lot clearer. But the reality is they were assisting the police in the investigation, whatever the motivation was.
And how were they assisting the police, Advocate? Mr. Hofmeyer?
Yeah, I think the main way that where we have proof is around the affidavits that they signed here. There is also additional evidence that I can point in my affidavits, the detailed billings that were done on the telephones and so on, that is also attached. That does track some of their movements and puts them at certain places at the time. I just haven't come prepared to sort of deal with those nitty-gritty details here. But we can embark on that process. I just need to have a bit of time to prepare.
I'm going to step off this and come back to it after the lunch adjournment, because you do make certain conclusions in paragraph 16 and 116 and onwards in your 2019 affidavit, and then refer to your evidence in this affidavit with reference to those pages in paragraph 121. So
Thank you, Ms. Bauer. I think that will assist all of us.
In paragraphs 122 onwards of your affidavit, you deal with the...
Sorry, can you just refer me to the paginated number?
Sorry, I'm now in your affidavit of January 2019.
Okay.
And I'm taking you to paragraph 122 thereof, which is on page, your affidavit starts at page 449.
Isn't it page 463?
Well, it starts on page 449 and the page is 463. Now, Mr. Hofmeyer, you were not personally involved in the Boyson matter, and essentially what you have detailed in paragraphs 122 onwards up until page 149 is your analysis of what you were aware of in the Boyson matter and your conclusions reached in relation thereto. Correct?
That's correct. I mean, we did learn, did get a lot of information about the Boyson's matter and what happened ex post facto. So I didn't know about these things at the time that they happened, but some of them emerged afterwards.
And essentially, your point of departure is, as you point out in paragraph 149, as a matter of law, are the powers that can and should be exercised appropriately.
Indeed. So, I mean, if I can just add, I think part of what made the process here looked very strange was the idea of bringing a DPP from another province to take charge of an investigation in a province where he had no jurisdiction. And I think the second part was the exclusion of Mlotshwa from the process, who I think was one of our more honorable, most honorable perhaps DPPs. He was certainly prepared to stand up for the right thing, as he showed at the time.
You draw certain conclusions from that,
Yes.
and those are your conclusions. Correct?
So it's a secrecy. I think there's one other issue as well, and that is we did have I'm trying to find where I mentioned it in my affidavit, but there was a sort of formal process to approve racketeering charges against anybody at the time. So there was a committee at head office that would look at the requests for racketeering and then would make a recommendation to the NDPP, who has formally to authorize any racketeering charge. And certainly from what I heard at the time from Mr. Mamabolo, who was one of the people serving on that committee, is that there were serious defects in the racketeering charges themselves, technical defects. I can't necessarily expand on those myself, but I think we can ask Mr. Mamabolo to tell us about that. But that's what I learned at the time, that not only was there this extraordinary move, there was a great secrecy around it, but also it was unclear, and I think as Judge Gorvin found later, that there was no grounds for authorizing a racketeering prosecution.
When you talk about a formal process that was put into play, is that a formal process that was put into place by who?
I think it was in place from fairly early on in the sort of racketeering offences were created in the Prevention of Organised Crime Act that I helped to draft in Parliament. So there were not many racketeering prosecutions in the early days, but I think the then NDPPs realized fairly early on that somebody with a high level of technical knowledge of racketeering does need to look at the charge sheet, at the charges, to make sure that we were not going to be embarrassed in court afterwards.
In paragraph 50 of your 150 of your affidavit, you seek to draw certain conclusions from certain cases that had been brought. And what is the point you're trying to make?
I think the point I am trying to make there is that there was an increasing tendency in the NPA to use our powers to prosecute against people who were seen to be, let me say, an obstruction or a problem to the president of the time. And I'm not, so I think those cases that I list there, in all of those, on almost all of those cases, people were removed from their positions in law enforcement. They were charged. In many of those cases, it didn't even proceed to trial. There was a discharge granted because of insufficient evidence in the docket. And I do believe fairly strongly that the Boysons or the Cato Manor case falls into that category.
In relation to that, how does that relate to Advocate Jiba?
I think it relates to her because it became clear, I was not part of many of these decisions, but there were certainly politically controversial decisions taken at the time, of which I can give some examples later if the inquiry would like me to do that. But certainly my sense at the time was that she was starting to play political games, to put it bluntly, with cases.
What was her position? She was Deputy National Director of Public Prosecutions at the time to which you're referring to.
Indeed.
And what did she control as in that position?
Well, I'm talking about the time when she was acting National Director.
I referred you to paragraph 150 of your affidavit.
Sorry, can you just repeat the question quickly?
You make the statement that these were cases that followed and were instituted in a blaze of publicity, and you, in your affidavit, point out that Advocate Jiba was in charge of all the prosecutions as head of the National Prosecuting Service. And my question to you was, what was the level of her involvement in the cases listed A to E?
I cannot testify to what the exact level of involvement was, but certainly if she was a diligent head of the National Prosecution Service at the time, I would have imagined that she would look very deeply into these cases and what had gone wrong. So I don't want to put it stronger than that, but it was clear that something was going deeply wrong in the NPA at the time.
So essentially A to E were cases in which people were charged and they were either not prosecuted after charges were brought. Well, let me rephrase that. There were decisions taken to prosecute. Is that what you say?
Yep, and many of them, and some of them, the prosecution started.
And then none of them went to fruition, except for the one with Advocate Breitenbach and Mr. Gerard Wagenaar, which resulted in an acquittal.
Yeah. I haven't looked at the details of these cases, but I do think some of them, there was a trial and there was a discharge at the end of the state's case.
I can deal with one further aspect before the lunch adjournment, which is on paragraph 151 of your affidavit, which would be on the next page. And you refer back to annexures to your affidavit in the Cape High Court, which is to be found at page 42 of the record. Sorry, I may have the wrong. Just give me a minute. I'm taking you to the wrong reference. Can you talk? You refer to this annexures. Maybe I'm getting the wrong annexure. Maybe this would be a better time to adjourn for lunch because we're 2 minutes away from lunch. I'll complete the question after lunch. We're at item number 4, and instead of us muddling through the annexures, let me just get an idea of precisely which annexures the deponent had in mind when he...
But the annexures are not here, they're somewhere else.
No, the annexures are here, but the annexure which I thought he was referring to is not the annexure as I paged to it. So that puts us in a slightly different position because I'm going to take him to the wrong page.
And also use the time to get the witness to walk through those affidavits and evidence that we referred to earlier.
Indeed.
And you will share the corrections with the parties?
I'll do that.
Thank you. It's adjourned until 2 o'clock.